Okay, hello everybody. My name is Stuart Davidson. I am a lawyer and a partner with the law firm of Robbins, Rudman, and Dowd. It's a law firm based in Boca Raton, Florida, and I'm here to provide you with a brief overview of some important information for ALS families regarding estate planning. So let's get into it. So let me just tell you all a little bit about myself. As I said, I'm a lawyer in Boca Raton, Florida. I've been practicing law for now it's going on about 28 years. I guess it was 27 when I first started preparing this presentation. I live in Boca with my wife, Suzanne, who is an accountant. We have two children. Our son, Aaron, is 22. He just graduated from the University of Florida and has applied to medical school. And we have a daughter, Lindsay, who is 19 and is currently a sophomore at Penn State University. How I first got involved with the ALS cause is that my father, who was a podiatrist in Buffalo, New York for over 50 years, just retired in, I guess it would be November or so of 2021. Within a couple months, he had been diagnosed with ALS, and he was 80 at the time, and he had just retired, as I said. So this was quite a shock. My father was an extraordinarily healthy man. He used to run marathons. He worked out every day and was preparing for, the next 20 years of his life in retirement. He passed away 6 months after his diagnosis. And that's how I got involved. So in order to help the cause and try to find a cure for this awful disease, I was appointed to the Florida Leadership Council of the ALS Association in February of this year, and I'm dedicating the rest of my life to helping ALS families and to trying to find a cure for this disease. Now, I am not an estate planning lawyer. However, during the course of caring for my father and, of course, caring for my mother, who was quite overwhelmed with everything, I had to learn a lot about estate planning to get my parents' estate in order for the eventuality. And so I dug very deep into estate planning. And by the time my father passed away, my family was in pretty good shape. So why do we care about estate planning now? Why do ALS families in particular care about estate planning? And here's a couple of reasons why. First of all, talking about estate planning is not necessarily an easy discussion to have. It generally requires consideration of the fact that life is finite and somebody is not going to live forever. So you're going to have that discussion with your family at some point. You might as well get it done now. Another very important reason is that you have a lot of things going on in your life as an ALS family. And as I experienced during the 6 months of my father's disease, those times can feel very chaotic, very overwhelming, and oftentimes it's very difficult to just get simple things done because your mind is moving a mile a minute. That being said, however, if you get your estate or the ALS patient's estate in order now, you will alleviate some of that chaos because it will give you a sense of relief that at least some things are taken care of and you can put them aside and not have to worry about them. And maybe this is easier said than done, but I do want to say that I had a tremendous sense of relief once my parents' estate was completed, because I did feel like things were finally in order and I could really focus the rest of my effort on making my father as comfortable and happy as possible. Importantly, if you do not have your estate in order by the time the ALS patient passes away, the chaos will just start from there. And it can be really chaotic if you do not have an estate plan in place. There are a lot of issues, including life insurance issues, probate court issues, and the like that will drag on. Those issues can be easily managed if you have your estate in order before anybody passes away. As I said, I know this because I lived it. I worked very, very hard during the 6 months my father was living with ALS to get his estate and my mother's estate in order. And I am telling you that this is a very important thing to do. And it does provide a huge sense of relief towards the end. Now, estate planning generally concerns 5 or 6, sometimes different types of issues. Some of them you will be familiar with, others you might not, and we're going to focus on a few of them. But in general, estate planning deals with a person's will, a person having power of attorney while they are alive, probate, which is a court in the county in which you live or you reside that will oversee the will, trusts, which are documentary instruments that we will talk about in a second, and what is called an advanced healthcare directive. And that is oftentimes referred to as a living will. So some of these things deal with the post-passing experience, and some of these things deal with while the person is still alive, as you can easily see. So what are some things that you can do now? I put an asterisk there because you will see at the end, essentially, I'm just assuming that everybody who is watching this has a will or knows what a will is. But if you do not, at the end of this presentation, my telephone number and email address are provided, and you are free to reach out to me, and I can help you with any of this information, including with the will. So the things that you can do now as an ALS family are the following. The first thing is to set up what's called a revocable trust. We're going to get into these in a little bit more detail in a minute, but I'm just going to list them now. The second thing is that advanced healthcare directive called a living will. Now, if the ALS patient is currently in the care of an ALS center, a multidisciplinary center, they may have already provided you with a document that is an advanced healthcare directive or a living will. If you have not signed that, or if the patient has not completed that because you don't understand it, the people at the ALS Center will absolutely understand and be able to help you. Again, you are also free to reach out to me, and my phone number and email will be at the end of this presentation. A durable power of attorney is another important document to have now. And again, I will explain these in detail in a minute. These are the 3 things that I'm going to go through very briefly to give you a general overview of what they are and why they are important. And I think all 3 of them are important. No one is more important than the other, but let's get into it. So what is a revocable trust? A revocable trust is an instrument it's a document that allows all of your major assets to be put in this trust such that when the ALS patient or anybody for that matter passes away, those major assets are not in the name of the person who passes away. They are not in that person's estate, but are instead in a trust. And why is that important? That's important because when an individual passes away, If he or she has any assets in their name that does not have a beneficiary attached to it, that means that when they pass away, that asset does not automatically pass to the beneficiary, like a life insurance policy, for example, then those assets become part of that person's estate. And what that means is that that estate then goes goes under the auspices of a probate court who will decide how to divvy up those assets under the person's will. If the person does not have a will, then the probate court has certain laws and statutes that it must follow to determine how assets are to be divvied up. Those assets are also available to any creditors of the decedent. So if there is a creditor, such as a bank or a credit card, that has not been paid and is due to be paid, then those creditors can go after the assets of the decedent's estate. However, if those assets are no longer in the name of the decedent because they are in the name of a trust, they are owned by the trust and not the individual, then they are not available to any creditors and they do not go into the decedent's estate and they are not part of the probate court process. This is very, very important. So what you want to do is make sure that there are no major assets in the patient's name when the patient passes away. So the way we did it for my father is that when he passed away, he did not even have an estate because there were no assets without a beneficiary in his name. Now, what types of assets? When I say major assets, what do I mean? I don't mean $2,000 in a Bank of America bank account. I don't mean a bicycle. I don't mean a chandelier inside somebody's house. I mean major assets, things that have a lot of value. And ordinarily, revocable trusts are used for the following: homes and condominiums, artwork and other valuable assets and commodities, and sometimes financial accounts as well. These are, generally speaking, a person's major assets. And the way that this will work is that the deed for a home or a condominium will be changed, and it's a very easy process, so that the owner of the home or condominium is no longer the individual, but the revocable trust. And you can essentially put any asset you want into the revocable trust. And again, the idea is to make sure that any assets that you own that do not have a beneficiary attached to them, that they will not immediately upon death be transferred to the beneficiary, that they are in the name of the trust. And who controls that trust? You can name anybody you want to control that trust. It can be a lawyer, but it does not have to be a lawyer. It can be a family member, and that is ordinarily who it is. So, for example, when my parents created a revocable trust, and the only things that were put in that revocable trust were their two homes in Buffalo, New York, and in South Florida, I became the trustee. And I became the trustee because we had a discussion, including with my sister and my wife, to determine who was going to be the best person to control that revocable trust. And they decided that would be me. And the trustee of the revocable trust can do anything he or she wants with the assets in that trust. They have obligations to make sure that they don't breach a fiduciary duty, but they generally can control the trust and control those assets just as if a regular owner of a home can do. So if you own a home, you can sell that home, you can rent that home, You can remodel that home. The trustee of the revocable trust can do the exact same thing. So you really just want to make sure that the trustee, as the name implies, is somebody that you trust. Well, let me go back for a moment. Also, financial accounts, as I said, oftentimes financial accounts, and not necessarily as much bank accounts as investment accounts. Investment accounts generally do not have beneficiaries attached to them. So you can very easily change the owner of an investment account from John Doe's investment account to the investment account of the name of the revocable trust, just like you would change a deed for a home or a condominium. That is very easy to do. Another way that a financial account can not have to go through probate and not be attached by creditors besides the revocable trust is something called a transfer on death. It is a very simple piece of paper that all investment advisors and financial advisors are aware of. And what this piece of paper does is it says, upon my death, this account, XYZ, will immediately transfer and become owned by my son or my daughter, or both of them equally, or my wife, or my husband. But what that means is immediately upon the death of the account owner, those assets in the financial accounts will no longer be in the name of the decedent, because immediately upon death, they will transfer that account, or those accounts will transfer to the other individual. And that's just as appropriate as putting the financial accounts in a revocable trust. Perhaps it's a little easier. And again, your financial advisor will know all about it. But just to kind of bring it back full circle, the reason why this is important is because when the account owner passes away, you do not want that money in that investment account to be in the name of that account holder and the account owner anymore. You want that money to be somewhere else, in the name of someone else through a transfer on death document, or in the name of the revocable trust. So in my view, the revocable trust is probably the most important document to have and to take care of as part of your estate planning for your family, because you do not want to have to go through probate court, which can be a very, very long process, and it can be contentious depending on the status of the person's will. And again, you do not want your assets to be available to creditors of the decedent as well. So I very, very much encourage you to talk to an attorney, an estate planning attorney, about creating a revocable trust for major assets such as homes, artwork, and financial accounts. The living will, or the advanced healthcare directive, is something that you want in place now. You want this in place regardless of whether you create a revocable trust. This is an important document that gives the ALS patient a say in his or her end of life. And I think it's very, very important to have. Again, it can be a difficult discussion to have that is certainly self-evident, but it nonetheless, you want to have a living will in place for the ALS patient so he or she can dictate what type of treatment he or she will get when things get bad. So what this is very simple. These are legal instructions for a patient's medical care if he or she is unable to make their own decisions. This is not limited to people with ALS, of course. I have a living will. My wife has a living will. We wanted to advise any family member and any medical professional of how we want to be cared for towards the end of our lives. And having this done now is gives you that opportunity. What this document will do, it will guide the doctors and caregivers when the patient is terminally ill, in a coma, in late stages of dementia, or near the end of life. And the patient may decide they want every life-saving measure to be employed for one reason or another, whether that be moral, religious, or just their own feelings. But this document, which you can have it say whatever you want it to say, will at least give doctors and caregivers the directives as to what you want done, and they have to follow those. And sometimes towards the end of life, or if somebody's in a coma, or if somebody has dementia, they cannot give those directives. This document will ensure that those directives are followed. Just like a trustee of a trust, a living will or advanced healthcare directive will appoint a person to carry out those wishes. That person can be anybody. Again, it does not need to be a lawyer. It can be a family member. It can be a friend who's a physician. But importantly, you should have the discussion with these individuals before you appoint them. Sometimes it can be a little awkward and may not work out right if you appoint someone without telling them that they are in charge of your living will. They may not like that, and they may not be the right person for that job. So before you appoint someone in your living will, talk to them about it. Tell them why you think that person is in the best position to be able to carry out your pre-disclosed wishes. And there usually is in a living will a provision for another person to become the person to carry out the wishes if the first person chosen does not want to do it, or for whatever reason is not available. And this also, for obvious reasons, will relieve the primary caregivers of the burdens of making decisions when they are in a crisis moment or undergoing a lot of grief. So having these directives in place really will make it easier on your caregivers to not have to worry about what decision you might or might not want. And again, it also would prevent confusion among family members generally as to what the appropriate steps should be, because those steps have already been laid out in the living will. And oftentimes, I don't know how often it is, but you can imagine a situation in which there are differences of opinions among family members, and those differences of opinions do not matter if there is a living will in place. And so it's an important document to have, and it's an important document to have now. And finally, a durable power of attorney. This is another document that is important and should be created now for the very same reason that the living will should be created now, because there may become a point in time in which the ALS patient is no longer able to make certain decisions about their life, and a durable power of attorney will appoint an individual as the patient's power of attorney to make certain legal decisions about that patient and financial decisions as well. So unlike a living will, a durable power of attorney cannot make healthcare decisions. They can only make financial and legal decisions on behalf of the individual. And so what a durable power of attorney does is it authorizes someone to act in a wide range of legal and financial matters, and will remain in effect even if the patient is incapacitated. The power of attorney ceases as a legal instrument upon the passing of the individual. But it is important to have while the person is alive, if they are unable to make certain legal or financial decisions or is otherwise incapacitated. That person who is appointed as the durable power of attorney acts as the patient's agent, or what's called an attorney in fact. Sounds like they should be a lawyer, but they do not need to be a lawyer at all. They are essentially a fiduciary to the patient to act in the patient's best interest with respect to legal and financial matters. And the types of financial and legal matters they can engage in are buying or selling property, managing bank accounts and investments, paying bills, filing tax returns. The only way, if a person is incapacitated and there is no durable power of attorney in place, the only way someone else can act in a fiduciary capacity for them is by obtaining a court order that the person is incompetent. The court system moves very slowly, and that can be a arduous process. So it is, in my opinion, a no-brainer to have a durable power of attorney in place. It only applies when the person is incapacitated or otherwise cannot make certain decisions for one reason or another, and certain things may need to be done, such as filing tax returns, paying bills, and managing investments. So having a durable power of attorney in place is very important. That's about it for the importance of estate planning for ALS families. I am always available. My name again is Stuart Davidson. This is my contact information. I don't necessarily know that the address is important, but the telephone number certainly is, as is the email. I can be reached at 561-750-3000. That is my office number. And my email is sdavidson@rgrdlaw.com. As I said early on, when my dad passed away from ALS, I decided to dedicate the rest of my life to trying to find a cure and to helping ALS families. I feel like I gathered a lot of information during the 6 months my father was suffering from ALS, and I really want to pass that information along to other families and to help them as much as I possibly can. So do not feel like you are bothering me at all. If you call or email me, I will always respond and give you my best advice. As I said, I am not an estate planning lawyer, but I am very close with an estate planning lawyer who helped me and my family in Florida, and would be happy to provide you that referral. So I hope this has been helpful to everyone. It certainly was very helpful to me to learn this information. It made our lives a lot easier during my dad's disease and certainly afterwards. Thank you very much and have a wonderful day.